Awesome. I'd like to call this meeting to order. Pursuant to the order of reference on Friday, April 29th, 2022, the committee will resume its study of Bill C-233, an act to amend the Criminal Code and the Judges Act, Violence Against an Intimate Partner. Today's meeting is taking place in hybrid format pursuant to the House of Order of November 25th, 2021. Members are attending in person, in the room, and remotely using the Zoom application. Goodness gracious. Per the directive of the Board of Internal Economy on March 10th, 2022, all those attending the meeting in person must wear a mask except for members who are at their place during proceedings. I would like to make a few comments for the benefit of our witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic. And please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. And fantastic, I just see our final members here, super duper. Reminder for drafting amendments. Before we welcome our witnesses, I would like to remind members to contact Alexandra Chira, the Legislative Counsel, as soon as possible, should there be any amendments to be drafted. The deadline for submitting amendments in both official languages is Wednesday, May the 11th at noon. Amendments should be sent to the clerk. On another note here, speaking notes, I got a call this morning from Megan Walker. She is unable to attend today due to family circumstances, and I have taken it to the clerk, and I would like to propose that our speaking notes be taken as read and appended to the evidence of today's meeting. Do I have the consent of the committee? Everybody's good with that? Happy choice. We're moving on. Thank you. I would now like to welcome our guests. And I would like to say to our witnesses, I'm very sorry that we are running late and starting late today. We did have 3 votes, but we're all here and ready for this. For our witnesses today, as an individual, and Francis Fortin, Associate Professor, School of Criminology from the Université de Montréal. Jean-Pierre Gois, Professor, School of Criminology, Université de Montréal. As an individual, Corinne Patterson, obstetrician and gynecologist. Luke's Place Support and Resource Center for Women and Children. We have Pamela Cross, who is the legal director. From the Recovery Science Corporation, we have Peter Marshall, the Chief Executive Director, and C. Strauss, who is a staff lawyer. We have them are with us from the Women's Legal Education and Action Fund. So I'd really like to thank each and every one of you for joining us. I'm going to be granting you 5 minutes each for your opening statements. You're going to see me start hooting and hollering over here, but I'd ask, since we have a large panel, I will be cutting you at that 5-minute point. I'm going to start by providing you each your 5 minutes, and I'm going to pass the floor to our first, and that is to Francis Fortin with the University of Montreal. Francis, you have the floor.
Merci, bonjour à tous.
Thank you. I would like to thank the committee for the invitation and for its interests in our work. A few countries have deployed e-bracelets to prevent domestic violence. This bracelet allows the geolocation of a spouse or ex-spouse who, in the case of breach of a perimeter of distance from the victim, sends an alert to a central station and allows a rapid intervention of the police on both the victim's and the offender's side. Jean-Pierre Gué and I had a mandate to prepare a feasibility study that aimed to analyze the measure by identifying the main issues facing the implementation of this device in the Quebec context. For our methodology, we used 133 documents. We did a synthesis of laws in 38 jurisdictions. We had interviews with police officers, justice officials, victims groups, and offender support groups. And we also conducted an analysis of the criminal history of offenders that my colleague Jean-Pierre Gué will present to you in a few moments. For our conclusions, several initiatives have been deployed around the world, and the e-bracelet can find its place among the various measures deployed to prevent domestic violence. This measure goes hand in hand with other measures. It increases the well-being and safety of victims. It makes it possible to secure the victim so we can intervene quickly. E-bracelets increase compliance with orders, but there can also be negative impacts. So good implementation should ensure that these negative impacts are reduced. For legal issues, the legal issues contain consideration of the stage in the judicial process where the bracelet may be appropriate and the balance between protecting victims and respecting the rights of offenders. It is important to understand that Section 810 or its equivalents exist in many countries and everywhere, and these orders are very difficult to enforce. The bracelet makes it possible to enforce a measure that has already been ordered by a judge in most jurisdictions. The implementation of such a technology also raises issues related to the choice of a device, its underlying technology, as well as an efficient and coordinated alert system with a police response. We also highlighted Quebec and the unavailability of certain technologies in remote areas. There are also ethical issues related to the privacy of the parties involved. So our report proposed several recommendations aimed at minimizing the impacts of the measures in order to find a balance between protection of victims and the rights and freedoms of offenders. The assessment of the risk and the choice of persons subject to the measure also deserve careful consideration. My colleague Jean-Pierre Guay will address this issue specifically. May I speak?
Merci beaucoup.
Thank you very much. Thank you, Mr. Fortin. Thank you for inviting me to the Status of Women Committee. It is very important for me to share our information on e-bracelets. In order to better understand the people likely to benefit from an electronic bracelet and thus propose scenarios for its use, we conducted an exhaustive study of the backgrounds of people who have committed domestic violence offenses in Quebec over a lengthy period of time. We have police data on the arrests of all perpetrators of domestic violence offenses in Quebec over a period of 10 years, and we analyzed the offenses committed by these individuals. We were able to draw a detailed portrait of the criminal paths of these individuals in terms of general, violent, domestic, and sexual crime. There were 116,805 perpetrators of domestic violence between 2010 and 2020. Approximately 30% of these individuals, so around 33,000, were repeat domestic violence offenders. In more than half of the cases, the time between the first and second offenses for which they were arrested was less than 18 months. We examined the relationship between the criminal histories of these offenders and domestic violence reoffending. The results revealed that the repeat offenders had extensive and diverse criminal histories. The best measure of the e-bracelet is probably one in which those most likely to benefit are correctly identified. Not everyone can necessarily benefit from such a measure due to a lack of human and technological resources, and my colleague mentioned it earlier. The report presents an analysis of the data and a scale to guide decision makers in assigning e-bracelets. And it uses simple criteria regarding the criminal history of offenders. These criteria could be used as a starting point for decision makers who could adjust their decisions to the specific situation of the individual. In Quebec, we are currently conducting a study on the effects of e-bracelets, and we will be studying offenses, the reoffending of perpetrators, the effect on the feeling of safety of victims and their families, as well as on the lived experience of people wearing e-bracelets. We have good expertise in order to implement this technology and to understand this technology, and our study should help us modify measures so that they are as effective as possible.
So much. We're now going to pass it over to Corinne Patterson. Corinne, you have 5 minutes. I do have your remarks with me, so I think we may be a little over time, but I'll just make sure that we ensure that any of your remarks do get put in the record for you, just if I do have to cut you off, okay? So I'm going to pass it over. Corinne, you have 5 minutes.
Thank you so much, and thank you for inviting me to speak today.
My name is Corinne Patterson, and I'm an obstetrician gynecologist in Manitoba, and I've been practicing here since 2011. I wanted to share with you my experience working with women experiencing intimate partner violence. In residency, we are trained regarding the basics of how to help our patients who are dealing with domestic violence. Firstly, we're taught to ask about it, knowing 25% of Canadian women will experience it. If a woman discloses domestic violence in her relationship, we talk about safety. We talk about having an exit plan. We talk about shelters. We support them if they wish to report to the police. We talk about leaving their abusive partner. Most of us became doctors because we wanted to help people, and this seems so straightforward when it was taught in university. Unfortunately, helping women in these situations is far more complicated. Women can go through all the right steps and still die, or lose the lives of their children. The loss of life of women and children from intimate partner violence across Canada is appalling. It has become a public health emergency that has been made worse by the pandemic. A woman dies every 1.5 days in this country. 30 to 40 children die every year from domestic violence. We can do better. We also know from a medical perspective that children who survive domestic violence do not emerge unscathed. Exposure increases the risk of adverse health outcomes, including depression, anxiety, and suicide. Physical illnesses, including obesity, heart disease, and cancer, are increased as well. If a woman tells me that she's being abused by her partner and she has children, we can discuss leaving. However, in Winnipeg, as is common across the country, it is unlikely that we will be able to have a shelter bed available for her on the day that she happens to need one. I remember once calling a shelter on behalf of my patient who showed up pregnant with 2 black eyes to my clinic, and I was told the wait for a shelter bed would be approximately 2 weeks' time. Not helpful. Women like this are often scared, and so am I. I know her risk of dying increases significantly when she decides to leave a violent relationship. I will often encourage people to get a restraining order. I also know in Winnipeg we do not always have the police resources to come right away. I know when she goes to a lawyer to talk about getting a divorce, they will possibly explain to her that a judge may feel, to quote the judge in Dr. Kagan's case, that domestic violence is not relevant to parenting, and I'm going to ignore it. I've heard from patients and from lawyers that their clients are aware of this phenomenon. It's become an unacceptable but understood fact amongst professionals. A woman can do every step right, but the Canadian judicial system is unable to consistently protect abused women in this country. Education on domestic violence is absolutely required to protect Canadian children. Specifically, pertaining to this bill, we talk about educating judges. They act as the final gatekeepers to justice for women leaving the path of abuse. If they are unaware of the full implications of their decision on the lives of women and children, how can we expect them to do their job properly? If any individual were to argue with me that this education is unnecessary, I would ask them to picture what 280 mothers and children would look like. That's 10 classrooms full of women and children. Even if with this bill we manage to save 10% of them, that is significant. We are asking judges to invest their time in learning how to save these lives. We know, according to the Canadian Domestic Homicide Prevention Initiative, that recent separation, domestic violence are the 2 biggest risk factors for domestic violence-related child homicide. Custody disputes increase this risk as well. If we can properly risk score these perpetrators, perhaps we can save the lives of children. Every judge needs to know these facts. I became involved in speaking about this bill because I was particularly touched by the media coverage of the case of Kira losing her life after her mother, a fellow physician, did all the right things. She left, she trusted the system, there's 53 court orders to prove it. Her daughter still died. Another physician, a mother of 3, Elena Frick, lost her life at the hands of her husband after suffering from significant domestic violence and telling him she wanted a divorce. A woman's risk of domestic homicide goes up 900 times when there is a history of coercive control, violence, and a recent separation. We are fortunate that research has been done that clearly demonstrates that ankle bracelet monitoring saves lives. ankle bracelet monitoring for offenders where the victim and police are notified if the perpetrator is violating a restraining order has been shown to reduce intimate partner violence associated deaths by up to 100% in some jurisdictions. I wonder how many Canadians could be saved by this technology, and I sincerely hope we get the chance to find out.
Thank you very much, Dr. Patterson. I really appreciate those words. We're now going to pass it over to Pamela Cross with Luke's Place Support and Resource Center for Women and Children. You have 5 minutes. Go ahead, Pam.
Thank you very much. Good afternoon. I'm very happy to be with you to talk about Bill C-233. I do so on behalf of Luke's Place Support and Resource Center in Durham Region, where I'm the legal director. And I'm happy to talk to you more about the work we do with survivors of family violence if we have time during the question period. First, with respect to judicial education. Luke's Place strongly supports judicial education on the issue of intimate partner violence, or IPV. The family law system in Canada is not always an understanding and safe place for women who have been subjected to IPV. Women face barriers simply getting to the courtroom. And once there, they're often met with a legal system that does not understand their experiences or hear their concerns. Just over a year ago, significant changes were made to the Divorce Act, making it mandatory for judges to consider family violence when deciding on parenting arrangements. These changes also introduced an expansive definition of family violence that goes well beyond the physical to include patterns of coercive control. And as we've just heard from Dr. Patterson, it's that coercive control that can be such a dangerous kind of IPV. Those changes to the legislation, important as they are only one part of the solution when it comes to protecting women and children, to saving their lives. Education for those tasked with applying the law is equally important if judges are to have the tools and resources they need to make effective, safe parenting decisions. Over the past year, we've seen excellent decisions that clearly reflect a deep understanding of the legislation and of IPV on the part of many judges. But we also continue to see decisions that lack that understanding. When a judge does not fully understand what family violence looks like and its harmful, long-lasting effects, decisions can be made that put women and children at risk. Stereotypes about violence and victims remain alive, and women who've been subjected to subtle, non-physical forms of violence continue to be disbelieved, continue to be re-traumatized, or even worse, they're vilified throughout the family law process. We strongly support judicial independence and impartiality, and the need to ensure that judges make decisions based only on the law and the facts before them. But to do so effectively and competently, judges require ongoing education about the laws that they're applying. This should not be controversial. We understand that a Memorandum of Understanding was recently signed by Chief Justice Richard Wagner and Justice Minister David Lametti, recognizing the judiciary's autonomy over education. We believe that this bill can coexist with the memorandum through the permissive language found in the Judges Act. While we generally support Bill C-233's proposed amendments, we suggest that it could be made stronger by including a provision that sets out suggested requirements for the creation and content of the training, similar to those in Section 63 in respective seminars related to sexual assault law. In the interest of time, I'll save my comments about the details of what we propose for that kind of education for the question period. We also submit that Bill C-233 should include an amendment to Section 3B to require that new judges undertake to participate in continuing education on matters related to IPV and coercive control. This obligation already exists with respect to sexual assault law and social context, and it should simply be expanded to cover the topic of intimate partner violence. Very briefly, we're not opposed to electronic monitoring as a mechanism for promoting the safety of victims and survivors of intimate partner violence. There's no doubt that this form of electronic tracking can provide women with an added level of security, and no doubt that it has the potential to increase both actual safety and feelings of safety. But we need to do more before we codify electronic monitoring. In order to avoid unintended negative consequences, let's take the time to find out more about when and how it will be used and whether it's appropriate in all circumstances. We have a list of questions that we believe need to be answered before proceeding with electronic monitoring, and I'm happy to share them and discuss them during the question period if time permits. Let me conclude for now by saying that Luke's Place supports Bill C-233, but encourages the committee to consider our proposed suggestions and amendments as a way to strengthen the bill and promote safer outcomes for women and children. Thank you.
Perfect, and thank you so much. We're now going to turn it over to Peter Marshall with the Recovery Science Corporation. Peter, 5 minutes.
Thank you. Just going to get my notes. Thank you for inviting me to appear today. Just have to get that out of the way here. My comments will be focused on the electronic monitoring provision of the bill, and to a lesser extent on the education component. By way of background related to the issue of intimate partner violence, I am a lawyer with experience in child protection and family law, having acted for children's aid societies, parents, children, and Ontario's Ministry of Children, Community and Social Services. In terms of experience related to electronic monitoring, my company, Recovery Science Corporation, started an innovative electronic monitoring program in 2010. We provide radio frequency, GPS, and alcohol monitoring. Because the availability of government-funded electronic monitoring programs is limited and inconsistent across the country, our privately paid program filled a need, as evidenced by the fact that our GPS monitoring program for bail developed into the largest such program in Canada, larger than any of the existing government-run programs. That experience gave us a front row seat as Canadian criminal courts formulated their reasoning and developed a body of case law about the use of electronic monitoring as a bail condition. Based on that background, I have 4 main comments for your consideration. My first comment is that while the bill would require judges to consider the use of electronic monitoring as a condition of bail, it may be worth considering extending the same obligation to all forms of conditional release that a judge may be asked to consider or approve, such as peace bonds, conditional sentences, suspended sentences, intermittent sentences, conditional discharges, and probation following a period of imprisonment, and parole. My second comment is that it may be worth considering whether and how similar obligations can be extended to decision makers other than judges. For example, when determining their recommendations, whether on bail, the withdrawal of charges in favor of a peace bond, or sentencing, and although ultimately subject to a judge's approval, Crown attorneys make decisions that have a significant impact on whether an individual is released into the community, and if so, under what conditions. My third comment relates to the availability of electronic monitoring. As I noted earlier, the reason that my company's privately paid program became so successful was because the availability of electronic monitoring is so limited and inconsistent across the country. For example, any particular province or territory may or may not have a government-funded program at all. And when they do have a program, they may have technological limitations, such as only offering one type of monitoring. They may have eligibility limitations, such as only making it available for some forms of community supervision, but not others, and limitations in the number of cases they can accommodate. If the intention is to ensure that decision makers impose an electronic monitoring condition in all appropriate cases, then electronic monitoring needs to be available in all jurisdictions for every form of community supervision, and using the form of technology that best addresses the risk factors identified in each case. My fourth and final comment relates to the judicial education provision of the bill. In addition to promoting general awareness among judges of matters related to intimate partner violence, it may be worth promoting the development of decision makers' risk assessment skills, and promoting practical knowledge of what can and cannot be expected of electronic monitoring. This will help decision makers recognize risk scenarios where the use of electronic monitoring is and is not appropriate, and when using it, help them to craft an overall set of conditions that best addresses the circumstances of the case before them. Thank you.
Fantastic, and thank you so much. I would now like to turn it over to the Women's Legal Education and Action Fund. C. Strauss, you have the floor for 5 minutes.
Thank you very much. Good afternoon. My name is C. Strauss. I'm a staff lawyer at the Women's Legal Education and Action Fund, LEAF. I'm grateful for the opportunity to appear today from the unceded lands of the Haudenosaunee and Anishinaabe peoples in the place that is now called Montreal. LEAF works to advance the equality rights of women, girls, trans, and non-binary people through litigation, law reform, and public education. I'd like to start by thanking and recognizing Dr. Jennifer Kagan-Viator for her leadership in pushing for this important and necessary call for judicial education on matters related to IPV and coercive control. LEAF supports judges receiving this training. However, we believe the bill requires specification about how it should be implemented, details that I will discuss shortly. On the other hand, LEAF has serious concerns regarding Clause 1 of the bill amending the criminal code. I will begin with our support for judicial education. Intimate partner violence is the most widespread type of violence against women, accounting for 45% of all violence reported by women aged 15 to 89. The risks of IPV are greater for women who are Indigenous, Black, and racialized, as well as for women with disabilities and migrant women. These risks are also greatly increased for people who are two-spirit, non-binary, trans, and gender nonconforming. Victims and survivors of IPV have struggled to make courts understand both the impact of intimate partner violence on themselves and their families, and the risk that such violence will reoccur. It's because of legal system actors' lack of attention to family violence and its impacts that LEAF strongly advocated for and celebrated amendments to the Divorce Act. These amendments, among other things, added a definition of family violence to the Act and mandated that family violence be a consideration when determining the best interests of the child. Significantly, IPV, including coercive and controlling behavior that is not physical, constitutes family violence. Yet identifying the presence of IPV and or coercive control in a partnership requires training. IPV is an umbrella term that encompasses complex, varied forms of abuse. It's often misrecognized due to gendered myths and stereotypes, as Dr. Patterson and Pamela Cross so eloquently shared. This needs to change, and it will not change without training. However, in order for such training to be effective, we believe the bill requires specification in certain areas. First, we recommend that training on matters related to IPV and coercive control should include social context. The way the amendment is currently worded, social context is only relevant for trainings on sexual assault. Yet systemic inequality in Canadian society, including colonialism, systemic racism, ableism, homophobia, and transphobia, has led to and can exacerbate intimate partner violence and stereotypes about survivors of such violence. In 2021, Indigenous women and girls made up 19% of femicides in Canada. Women with a disability are twice as likely as women without one to have been the victim of a violent crime. It is critical that judges are aware of these realities when assessing the presence of and impacts of intimate partner violence. In addition, educational materials on IPV and coercive control should be created in consultation with survivors of intimate partner violence and organizations that support them. For this reason, we would recommend that a provision similar to Section 60, Paragraph 3, be added to the Judges Act in respect of training on IPV and coercive control. Trainings should also include information on the different forms of IPV, the well-documented social reality that family violence is a gendered phenomenon, and the impact of trauma on a survivor's memory, demeanor, and well-being. Finally, we would recommend, as Luke's Place does, predicating eligibility to become a Superior Court judge on a person's undertaking to participate in continuing education on matters related to IPV and coercive control. This was a crucial element of Bill C-3, formerly Bill C-5, and without it, one could not be sure that any judges would in fact attend trainings in sexual assault law at all. This bill should provide the same reassurance. Briefly turning to the bill's proposed amendments on electronic monitoring, there are some concerns that should not be ignored. It's important to note that electronic monitoring is already available to judges as an option when considering bail conditions. Electronic monitoring may make some survivors of intimate partner violence feel safer and may serve to protect survivors and their children from harm in certain cases. However, as has been already said, this will not be the case for every person. For this reason, electronic monitoring should be a condition that is available to judges, which it already is, but it should not be something that judges are required to consider, as is proposed in this bill. This is because there is a significant likelihood that if judges are required by the criminal code to consider a particular condition, it will end up being added to bail conditions as a matter of course. With electronic monitoring devices costing hundreds of dollars a month, the routine addition of electronic monitoring as a bail condition will have devastating consequences for low-income families. This may actually detrimentally impact the interests of at least some survivors. Thank you for your time. I'll be happy to answer any questions you have.
Thank you so much to our witnesses on our panel today. What we'll be doing is our first round of questioning. We'll be starting off with 6 minutes for each party. I will be passing the floor over to them, but I'm just going to always remind people we're at 6 minutes for our first round, so I will be cutting people off since we're tight on time today. So, Michelle Ferrari, I'm going to pass the floor over to you for 6 minutes. Go ahead.
Thank you, Chair, and thank you to all of our witnesses. Great testimonies, and thank you for being here today with your thoughtful and insightful suggestions. I'm going to start with Pamela Cross. Ms. Cross, you recently completed the delivery of domestic violence awareness training to approximately 2,700 Legal Aid Ontario staff, community clinics, and lawyers across the province. What was the result of this training, and do you believe that same training would be beneficial and useful for judges?
Thank you for the question. I'm going to answer the second part of it first, if I might. I think that what judges need to know is somewhat different from what lawyers need to know. The training work that I did with Legal Aid Ontario was aimed not just at lawyers, but with all of their staff. And it was very much focused on, in addition to understanding what intimate partner violence is, especially coercive control, how to identify it. And that's not really something that a judge is in a position to be doing to the same extent. So while I think there are some commonalities between the work that we did with Legal Aid Ontario, the education that we're talking about for judges, and C. Strauss has gone into this in some detail in their presentation, needs to focus on what's going to help a judge make a decision when they're hearing two stories very differently told by the two parties who are appearing in front of them. As to whether or not the work we did with Legal Aid Ontario was effective, I would say yes, although I'm probably not an impartial judge of that. One of the things that was great about it was it happened before the pandemic, so we could train people in person, sitting in a room, having conversations, and I think that's a really important part of learning. It was a full day training, so it was rich in terms of the material that we could cover. The evaluations that were completed by the participants were extremely positive. A lot of people, and maybe this is the most telling thing I can say, Michelle, in response to your question, a lot of people came to that training reluctantly, thinking they already knew what they needed to know, or thinking that they were going to be turned into anti-father biased lawyers. And I can't tell you how many people spoke to me personally at the end of those days of training saying, wow, this isn't what I was expecting at all. I learned a lot here. I'm going to be able to take these very practical tools away and put them into practice in my work as a lawyer representing moms, dads, children, various people who require representation in family court. You'd have to talk to Legal Aid to get a more comprehensive assessment as to whether or not they feel that there have been long-term benefits from the training. But even 3 years after we completed that contract, we still hear from lawyers who say how helpful it was to them.
Thank you so much. That is very helpful. And I was going to ask a different question, but you've opened the door for a conversation that I'd like to have. And I'm actually going to direct it at C, if that's okay. I've been contacted about this bill by multiple people, in particular fathers, who've also been victims of abuse. And I just am curious what your thoughts are on the way the bill is worded to ensure gender equality, that it is taking care of all genders, that it's not specific to just women.
Sure. Thank you very much for the question. So right now the bill is worded to ensure gender equality, I believe. I think that, I think it's important to understand who is who the reality that women and children are those most harmed and affected by family violence. So while, of course, that is not, they are not the only people affected by family violence, fathers and men are as well. The reality is that intimate partner violence is a gendered phenomenon, and we believe that that should be a part of training for that particular reason. So while right now I do believe that the bill is drafted in a gender neutral way, we actually think that it should be, that training should ensure that judges understand the gendered nature of intimate partner violence and family violence.
Thank you very much for that. One other question, and this was to Frances Fortin. Frances, you had said negative impacts of the ankle bracelet, and I just wanted you to expand on that, if you could, of what you mean by that.
En fait, ce qu'on a,
So, when we examined the different measures, we noticed that there's this idea that wearing the ankle bracelet can be stigmatizing, and the fact that that person would always have to have the device on them, and other panelists have mentioned this as well. We have suggested being cautious so that there aren't false positives. So we need to take the time to choose the person that will benefit from this e-bracelet the most, because in certain cases it's not the appropriate measure. So one needs to examine that possibility, because that choice can have a negative impact. So it also can talk about what it represents for both parties and privacy.
Hopefully we'll be able to get back to that, but I'm going to pass it now over for the next 6 minutes to Pam Damoff. Pam, you've got the floor.
Thank you. My first question is for Leif. You mentioned concerns around social context, and I'm wondering if we were to move the wording so that it said sexual assault law, and then moved the matters related to intimate partner violence and coercive control before the words social context, if that would address your concerns.
Yes, precisely. So
Okay.
it would be, yeah.
So we'd
it
just
would
be
a way
moving
in
those
which
words.
It would be matters of, sexual assault law and intimate partner violence and coercive control, all of which includes social context, including systemic racism and discrimination.
Yeah, just moving the location of it. And I was happy to
Exactly.
hear both you and Ms. Cross speak about the need for it in the clause that deals with undertaking. And if we were to do that, we could do the same thing there, is ensure that the wording is put prior to the words social context. I did hear your comments about the electronic monitoring, and I saw that you put a tweet out earlier today as well. Would you feel more comfortable if in that clause around electronic monitoring there was some definition that it was where there was violence against an intimate partner? So making it more defined that it was intimate partner violence that was threatened or attempted?
I think that clarification is already present. Right now it is being considered for offenses that are more than just against an intimate partner, but our concern is more that if wearing a device becomes a routine condition of bail in circumstances including IPV, those who can afford the device will be released and those who can't will remain in remand. And given the correlation between being low income, criminalized, and Black and or Indigenous, the effects of this proposed amendment will likely increase over-incarceration of Black and Indigenous people.
But it's not prescriptive, right? It's just, I had actually Philip Viator spoke to me, and he supports it because it said it just highlights as an option for a judge, and often it doesn't go to a judge but a justice of the peace. So he actually thought that it was a good thing. But I hear you and respect your opinion on this as well. Certainly, those who are lower income are more likely to be remanded. There's no doubt about it. I guess to Ms. Cross, when we're talking about electronic monitoring, one of the things I liked about this bill is that there is a connection between education of the judge to be able to understand coercive control and domestic violence and knowing whether or not to ask for electronic monitoring. So do you not think that education piece will enhance who is recommended to have e-monitoring?
Certainly it will. My concerns are really practical in terms of the implementation of electronic monitoring. I just came home a couple of days ago from spending a week in Renfrew County. Next month, an inquest is beginning in Renfrew County into the triple femicide that took place there in 2015 that I'm sure many of you remember very well. And I was talking to people in the community to put together a report to go to that inquest about the impact that those murders have had on the community. And one thing I heard again and again is that legislation that's written as though everybody lives in an urban area has got to stop. In that situation, some of those victims lived in locations where it wouldn't have mattered what kind of electronic monitoring was underway. The police would not have been able to respond quickly enough to save their lives. So when we talk about this, I just want to have those conversations before we make something a law that is not going to give equitable access to justice. C has talked about economic and racialized lack of access to equal justice. I'm going to talk about people living in rural locations. What happens when someone has electronic monitoring and there's a power failure, or they live in a part of the province or the country where there isn't sustained
so I'm going to stop you there because I have another question, and I think those are all extremely valid points. In fact, Ms. Gazan brought that up last week when we were discussing the bill, but I don't know that it means that we shouldn't move forward with it when it's an issue to recognize. Coercive control is not defined in the criminal code. Do you think it would be helpful if we added coercive control as it relates to intimate partner violence and family violence into the definition? Do you think that would be helpful from the education perspective?
Absolutely.
Okay.
Absolutely, I do.
And I think I'm almost done my time. 40 seconds. I'm just going to say I love the background when I come to Status of Women because we have Thelma and Louise and high-heeled shoes. So, Chair, I'm going to give you back the time because I don't think I have time to get a response.
Okay, not a problem. Well, thank you very much. I'm now going to pass it for the next 6 minutes over to Adrienne LaRoche. Adrienne, you have the floor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. I would like to thank all the witnesses for being with us today and to talk to us about this bill. I would like to address my questions to witnesses Cross and Strauss. So there would be a new condition that judges need to take into account with bail under paragraphs 515 of the Criminal Code. So if an attorney makes the request, a judge must decide whether or not to impose the use of an e-bracelet. I was wondering if you were able to examine this, and with this new legislative measure, a judge could not impose the use of an e-bracelet without having a request made by the Attorney General. And what do you believe about this, that it has to be by request and not at the judge's discretion? Have you had the opportunity to reflect on this?
Madame Cross, Madame Strauss.
Ms. Cross or Ms. Strauss?
I mean, ultimately, the judge has the discretion whether the request, sorry, let me put that the other way around. Even where an attorney, and presumably that would be the Crown attorney, fails to make the request, under present legislation, judges have a wide array of options available to them in terms of what happens to this accused person during the remand period. I haven't looked at that question in detail. As I said in response to an earlier question, my interest in the bill is more focused on ensuring that it's actually something, if introduced, will work in an equitable way for people wherever they are in this country. So, I don't know if you want to add any comments to that.
Sure. Thank you very much for the question. The standard way that bail works is that bail is supposed to be issued without conditions unless otherwise required. So it's up to the Attorney General to oppose bail, to oppose judicial interim release, and it's up to the Attorney General to, provide reasons for that, which is why it's up to the Attorney General to request this condition. I don't see anything wrong with that. I think that makes sense in terms of the standard course of things. Our worry is that, bail conditions often develop into a standard set of conditions requested by the Crown, regardless of the individual circumstances of the accused. But in all cases, judges do have discretion, and judges should have the flexibility to decide whether to impose this or not, as they already do. Thank you.
Merci beaucoup. J'entends.
Thank you very much. So thank you to both of you. And my next questions are for Mr. Fortin and Mr. Gay. Do you believe that the legislation as it is currently could be correctly implemented? Are there sufficient elements for a proper implementation in your view? Answer. I might have a little bit of difficulty answering this clearly, but I will give you some aspects of an answer which could perhaps clarify the different points of view. Our sample may not be very representative, but when we worked with police officers, justices, different groups, what we heard was that, in general, people wanted a judge to impose such a measure. That's what we heard during our research, and we are not lawyers, but in the implementation, it seems overall a good way of presenting things. It needs to be seen as a toolbox, and I find it difficult to speak on such a legislation and to impose upon judges a way of doing things. In our work, we noticed that a judge will be able to factor in the situation and examine the aggravating circumstances and other circumstances, and I don't think we should go against that, because the judge is the most well-placed person to see whether or not such a measure should be applied. I don't know if my colleague has anything to add. No, I agree. Perfect. And again, some research has shown that the e-bracelet can be effective regardless of some of the negative impacts. What can we expect for the decrease of assaults in Quebec and in Canada? Have you examined that and the training of judges, and have you examined other jurisdictions and examined the impacts? Answer. I can try to answer this. So, there seems to be a decrease of violence against women with the use of e-bracelets.
I'm sorry about that. I do know the question's a lot longer, but I do need to cut you off so that we can go over to our next 6 minutes of questions with Leah Gazan. So we'll get back to this if you don't mind, but I'm going to pass the floor over now to Leah Gazan for 6 minutes.
Thank you so much, Chair. I have questions for Madame Patterson, Cross, and C. Strauss. So if we can be brief in response. It's so nice to see everybody here, and I just love your brains. I wish I had more time. It's so nice to see you again, Dr. Patterson. You spoke specifically about Winnipeg and the lack of shelter, something that I'm fighting really hard for in our community. We don't have space. And I ask this question because it becomes especially concerning and more volatile for women who choose to disclose something very difficult, especially if they choose to take a legal route to deal with their perpetrators. With this in mind, how important do you feel it is for judges to get proper training to improve their judgment in cases of intimate partner violence?
It's frankly essential, because what happens now is if somebody tells me that they're experiencing intimate partner violence, I will put in the time, I will do everything I can to find a shelter bed or alternative places for her to go, which I have some excellent social work resources. It's not simple though. And then when they ask and they assume that the courts are going to take care of them, that if they leave their abusive partner, they will be able to have custody of their children, and that's going to be taken into account. And I have to sometimes explain, I often will say, you should talk to your lawyer about that. But I'm friends with lawyers. It's an unspoken problem in this country where the lawyers fully know it really just depends on the judge. There's excellent judges who are well educated on the topic, and then there's not. And I have to believe that Canadian judges are not, they don't want women and children to die, right? We're all on, I think we can all agree across the country we can do better. And the way we can do better is being proposed in this bill. And is it perfect? No, there will still be loss of life. There's still going to be violence. It's not going to get into every pocket of the country, especially the rural areas, as was mentioned. But that's like saying we shouldn't treat cancer because we know some people won't survive, and it's not fair.
Thank you so much, Dr. Patterson. C. Strauss, so nice to see you again as well. There's a couple of recommendations you make to strengthen the bill. One is developing the education and consultation with survivors and organizations that support them. And the second one is ensuring that the education covers systemic inequalities in Canadian society. I agree with you, especially on the second point, especially looking at the inequality and the issues with the justice system, even identified in the National Enquirer, but also the Aboriginal Justice Inquiry a million years ago. Could you speak a little bit to these recommendations for strengthening the bill?
Yes, absolutely. So in my remarks, we'd already recommended that social context be added in order to be accounting for these systemic inequalities. We also think it's important that when consulting with survivors and organizations, that also reflects the diversity of people in Canadian society, especially those who have lived through conditions of marginalization, such as systemic racism, and who directly understand how marginalization impacts their experiences of intimate partner violence. So any added section about consultation should include meaningful consultation and input from individuals with lived experiences of oppression, particularly individuals or orgs that serve populations that are Indigenous, Black, racialized, live with disabilities, or live in poverty.
Thank you so much for your response. Madame Cross, you said that the bill could be made stronger if there was ability to provide some sort of input in terms of the outline of the training that would occur. I was really happy to hear you say that, because one of the concerns I have with this bill is the fact that judges have too much control over whether they take the training or not and the content of that training. And from what we've heard is that usually the judges that don't want the training are usually the ones that need it the most. Can you please expand on that? Thank you.
Certainly, I'm happy to do that. Thank you for the question. And I'm just going to build on what C. Strauss has already said rather than repeating her very excellent comments already. It's critical that this education be developed outside the judicial world, both for the reasons that you've mentioned, but also to ensure that real expertise is brought to the question of what the content should be. That's one of the things that was so great about the legal aid training that we talked about a few minutes ago. And that training has to look at all of the things that C has talked about. It's got to look at the gendered nature of intimate partner violence, especially coercive control and especially lethal intimate partner violence. Or it's not an accurate picture. We cannot have judges continuing to say, well, you know, it's a bit of this, it's a bit of that. Sometimes it's him, sometimes it's her. He said, she said. We don't know how to interpret this. There is clear evidence that says that women are primarily the victims of coercive control and intimate partner homicide. That has to be part of the training, in addition to the many points that have already been made, in particular by C.
Thank you so much. We're now going to begin our second round. For our second round, it'll be 5 minutes for the CPC and the Liberals, 2.5 minutes for the Bloc and the NDP. So I'm going to pass the floor over now to Shelby. Shelby, you've got the floor for 5.
Thank you. Ideally, I'd be able to ask all of you questions, but I'm going to get through as many as I can. I'm going to start quickly with Pamela Cross. So after you answer this question, the rest of you feel free to chime in if you'd like as well. The bill as it stands clearly does a lot to help keep victims of intimate violence physically safe. But I really think that that's only half of the equation. I cannot imagine the amount of trauma, of emotional and mental trauma that still exists, even though the partner and any children that witness the abuse may be physically removed from the situation. So could you possibly elaborate on the importance of mental and emotional supports in the immediate aftermath of these situations for the victims?
Thank you for the question. I can't say enough about that, especially in the small amount of time that we have, but you're absolutely right. Removing the physical danger is step one, but tied with that has to be access to supports, including supports like shelters for women and children, so that work can begin to address the trauma that often can last for years and years and years, leaving that woman vulnerable to ongoing abuse by the partner, even long after she's left the relationship. And that speaks also to what needs to be involved in judicial education. Judges need to understand that just because she moves out or he moves out, that doesn't mean that the abuse has come to an end. It continues. It often escalates. It becomes increasingly lethal, and it becomes more psychological. So the impacts of all of that on the woman and, as you said, on the children as well, have to be matters that judges understand clearly and that they take into account when they're making decisions about parenting arrangements that can find themselves in place for years and years if the children are very young.
Perfect. Thank you very much for that. And I'd be remiss if I didn't acknowledge all of you at the very beginning for your testimonies. I find many of them quite compelling. My next question would be posed towards either Dr. Patterson or Mick Strauss. So this one in particular, have either of you experienced a situation where a judge was sitting on a case relating to a matter that wasn't their specialty?
Judges are often sitting on a case relating to a matter that isn't their specialty because judges hear a wide variety of cases, and often somebody will be, a real estate lawyer who's all of a sudden hearing a family law case. So this is had been a real estate lawyer before they became a judge. So it's a very common thing. It's why judges require training. It's why important institutions like the Canadian Judicial Council exist to provide that training. But because of the immense significant gap between what judges understand and what the reality is of intimate partner violence, this is one of those things, as with sexual assault law, that requires specification to judges that they undertake to take this training if they are to become a Superior Court judge.
Okay, thank you very much. That's disturbing. So perhaps could all of you share your consensus that you do believe judges require adequate training on domestic violence before they hear these cases?
100%.
Across the
Yes.
board? Yes.
Absolutely.
Okay, fair enough. Thank you. if I have time, if it's allowing me. Okay, terrific. So I'll switch gears and ask Peter Marshall a few questions. Just a yes or no to begin with. Mr. Marshall, you've got 20 years of experience in the child protection and family law, and would you say that domestic violence plays a role in custody court hearings?
Well, it's certainly raised as an issue in many cases, yes.
And second, would you then say that it's imperative that judges should be accurately trained and educated on domestic violence before hearing the case?
Yes.
Yes. And another question, does Recovery Science Corporation conduct research on the effectiveness of ankle monitoring?
We try to be aware of the research. I wouldn't say that we have done original research that would be, of the same sort of extent and quality as the professors have done. We're really more closely connected with how courts are using electronic monitoring.
Okay, that's fair. Is there any way that, are there any statistics that you could provide the committee with regards to the effectiveness of the ankle monitoring?
I think effectiveness is just a really complicated issue to try to measure, because when somebody's released with electronic monitoring, there are so many other variables.
Awesome. Thank you so much. We're now going to pass it over to Jenna Suds. Jenna is online and we'll have 5 minutes. Go ahead, Jenna.
And I'm actually going to pass it to Yara Stacks in the room.
You have the floor for 5 minutes.
Thank you so much, Madam Chair, and thank you to all our witnesses who are here today, and thank you to PS Suds for being so generous with her time. So I have a few questions, and I want to start with C. Strauss and with Ms. Cross. We've discussed here that in terms of defining coercive control, we do have an understanding that it is persistent whether the couple is still together or not, and it can escalate and has psychological and potentially lethal harm that then leads to intimate partner violence. And that there are clear markers as the process goes on through the courts or as they're trying to separate the individuals. But both of you raised concerns about, in terms of stakeholder input on the judicial training process itself and creating the trainings. And I'm wondering, with the sexual abuse training that was created, if there's precedent for that in terms of what kind of inputs were put into place, if you're aware of them.
I am not aware of the inputs into the sexual abuse training. I know though that what that is in the Judges Act. It was put into the Judges Act that development of the training should be done in consultation, and in particular, I believe in the Judges Act it mentions with Indigenous organizations. So we are proposing to broaden that as we did in our submissions on that on Bill C5/C3 at the time. So there is precedent for that in terms of what's actually in the Act right now.
In the Act. So thank you. So just to clarify, so as legislated, it does include stakeholder participation in the development of the training, so that there is precedent.
Yes.
Okay.
For sexual assault law.
For sexual assault law. Okay, that's an important point, as many of my colleagues have spoken to that point here. And precedence, as we all know, is everything in moving something like this forward. I'm going to move on and ask a question with regards to, there was a recommendation about a 30-day coming into force clause for royal assent so that provinces and territories can prepare. Could either of you comment on that in terms of putting the recommendation forward? Or anyone else on the panel for that matter? No? Either Ms. Cross or C. Strauss?
Yeah, Ms. Cross, if you want to answer that on.
The only comment I'll make about that, and it's a fairly general one, is that in 2021, when Bill C-78, which introduced these massive amendments to the Divorce Act that a number of us have mentioned this afternoon, when that bill was passed, it resulted in some inconsistencies between provincial and federal family law. So in Ontario, which is where I am, the Children's Law Reform Act did not reflect the same approach as was being taken by the Divorce Act, which put families in complicated situations in terms of trying to select the appropriate legislation to use. So I think that as we move ahead with any kind of legislation at the federal level that has implications at the provincial level, for example, the division of power such that provinces are responsible for the administration of justice, we have to build in time to allow provinces to get on board so we don't have inconsistencies or gaps between what's passed at the federal level and what's actually playing out on the ground at the provincial or territorial level.
Okay, Madam Chair, how much time do I have?
You have 1 minute, 45 seconds.
Okay.
1 minute, 4 seconds, sorry.
1 minute, 4 seconds. So I will do my best to try and get it in. I'll move to electronic monitoring here. And as one of the supporters of this bill, when we put electronic monitoring in alongside with this training, it was the idea of create education and then create an optional tool. And as we've heard from witnesses, there is context to this that needs to be considered. What kind of guardrail? We've heard some comments, but what other guardrails would you recommend if electronic braceleting is an option? What other training or guardrails to the legislation would you want to see for its potential use, but in a limited scope?
You have 20 seconds.
A written submission on this would be fine if anyone has an answer as well. No
I'll just say that it already is an option for judges now. So the guardrails are already in place in a way and not requiring judges to consider it, which might make it just a matter of routine recommendation.
Perfect. Thank you so much. Sorry, I got to get my clock off. Thank you so much. We're now going to pass it over for 2.5 minutes. Just make sure I've got this. 2.5 minutes to Adrian. Adrian, you have 2.5 minutes.
Merci beaucoup.
Thank you very much. Again, thank you to the witnesses. And I have another question for Mr. Gay. You had started to respond to my question and ran out of time. So it had to do with the positive impacts of the ankle bracelet and also other jurisdictions, for example, Spain, Australia, the UK, that have an ankle bracelet. So with other jurisdictions, can we foresee a decrease in assaults? I will give you more time to respond. So, with regards the advantages of the use of the ankle bracelets, we have noticed a decrease of violence towards victims in other jurisdictions, an increased sense of safety when we examine the victim's experience. Now, with regards to reoffending, this is a complex matter, and we talked about the importance of the risk assessment of a person, and what we've noticed is that an e-bracelet does not decrease the risk of reoffending. It allows people to better participate in activities to reduce their risks of reoffending. But the worst offenders could end up reoffending. It stops a person from reaching a victim, for example. So it does have advantages, but if we were to examine simply the success of measures versus reoffending, it would be difficult to be satisfied with these measures. So I don't know if I answered your question. Yes, thank you. So there needs to be a continuum of services. So there needs to be other services for victims, not only the bracelets. That's what I believe you said. Answer: yes. A bracelet alone will not solve all the problems. Quickly now for Mr. Fortin.
Well, I'm going to have to pass it over.
Liberté des victimes.
I'm sorry. We're going to pass it over to Leah Gazan. We will do our best to get to you. Leah Gazan, you've got 2.5 minutes.
My question is for C. Strauss. You spoke a little bit about the importance of having a gendered lens in the training for judges. And you spoke a little bit about stereotypes that often impact victims of violence. One of the things that I brought up in the last session was manipulative parenting. Certainly in the case of Keegan, where the mother came forward with all these concerns about the father, they were dismissed, and then Kieran ended up losing her life. And I'm wondering if you could speak a little bit to that. I guess my concern is the fact that we know that 81% of victims that lose their life to violence are women, and there's a high percentage of children that also lose their life, and why it's particularly important to understand domestic violence from a gendered lens.
Yes, thank you for the question. So it's really everything that you just said. The problem is that there are these myths and stereotypes, and I'll just be speaking from a great piece written by Deanne Sauter and Jennifer Koshin, who just say that, the idea that women make allegations of family violence to gain an upper hand in family law proceedings, or that they're alienating their children from their former partner out of some sort of vengeance or spite rather than concern for their children's safety. These are based on myths and stereotypes that are really similar to those that are recognized to improperly taint the credibility of sexual assault complainants. But for whatever reason, there is more of an understanding these days that there are these myths and stereotypes in the sexual assault context, even if, they're not properly applied still. Whereas in this context, in the intimate partner violence context, there's a real lack of acknowledgement in the public that these same myths and stereotypes exist and function. So even though it's not that these things never happen, but judges readily accept accusations that allegations of family violence are false without doing impartial fact finding and paying attention to context. And so this bill will help with those issues because, women are more likely to be accused of falsely claiming family violence, even though underreporting of family violence is known to be widespread. So there's a big disconnect here.
Awesome.
Thank you.
Thank you so much. I'm now looking at the time, recognizing how tight we are getting out in time. We do have a special guest with us from the Green Party, and I know Mike would like to ask a question as well. So I would just like to ask with the committee, what I'd like to do is reduce the time. So we would just reduce the time for each party, and then Mike, pass the floor over to you for the final question. Can I get the support of the committee? Are all of those in favor? Anyone not in favor? Please let me know. Anyone not in favor? Fantastic. So what I'll be doing is messing around with the time like I always do. I'm going to, Dominique, you should always be confused with me. You're going to get 2.5. We're going to start off with 2.5 minutes, 2.5 minutes, 2.5 minutes, 2.5 minutes, and then last question, sir. Okay? So I'm going to pass it over to Dominique. Sorry, Dominique, 2.5 minutes.
Merci beaucoup, Madame.
Thank you very much, Madam Chair. I'll be brief in my questions. My questions are for Mr. Francis Fortin and Mr. Jean-Pierre Guay. We've been talking a lot about this bracelet and its use. Can you tell us concretely how it works so we can properly understand it? Earlier, you mentioned that a victim could feel safer, and there's also privacy matters. How does it work? So a judge orders the wearing of a bracelet. The victim has a device with her. Can you just explain how it works? I will try to respond as quickly as possible. So, firstly, the offender wears the bracelet, but it's an ankle bracelet. It is not visible. It can be hidden, but it is to be worn. The victim has a device that has a panic button in the case of an emergency. So we determine a distance, and both devices cannot be within X kilometers. So that, again, is up to the judge to decide. And when there's a proximity alert, what happens is there's a call made to a central agency, and then it is decided whether or not it is a false alarm. It is transferred to police services, and there are 2 cars sent, one for the offender and one for the victim. And we hope that everything will be done quickly. Does that respond to your question? It does. And another quick question for you privacy stops and begins where for an offender? So what we've seen, well, the device shouldn't register if there's no proximity alert. If there is a proximity alert, well, then the device will record the geolocation, and same thing for the victim. So that's the limit that is generally well accepted. If we don't need to use the information is not kept. Same thing if a police officer asks to have that information, they won't be available.
Very much. We're now going to flip it over to Emanuela Lombropoulos. You have 2.5 minutes.
Thank you, Madam Chair, and I'd like to begin by thanking all of our witnesses for being here today to offer their amazing testimony on a very hard topic. My first question is going to go to Pamela Cross. I know that during your testimony, you mentioned that you would like to dive a little bit more into the contents of what should be taught to these judges. And if you haven't had the opportunity yet to do so, if there's any extra content pieces that you think should be included in the education that they receive, and any additional circumstances also that should be considered in terms of context. If you'd like to elaborate on those and mention anything that you haven't had the chance to already.
The only thing I would add to what has been said, not just by me, but by others this afternoon, is that intimate partner violence looks so different from one situation to the other. You know, we've talked a lot about coercive control, and that's important because it is very under-recognized. It's often invisible to an outsider. But we also need to look at that whole spectrum of typologies of behaviors that constitute intimate partner violence. And judges need to understand that there's no, oh, this is what a victim looks like, or this is how a victim reacts or responds or behaves. None of that. You can't tell by looking at somebody. You can't say, well, she wasn't hit, so it's not as bad, or it was just a question of him being in charge of the money. That doesn't mean he was controlling her. There has to be education that looks at, as I say, that whole very broad range of typologies, of tactics, and understand that very often in a relationship, there's a combination of tactics being used, combined differently at different times, but generally escalating over the length of the relationship.
Thank you. And Ms. Strauss, if you'd like to add anything, I know that you spoke to this as well. And then a final question for Ms. Strauss. Also, you mentioned in terms of the electronic monitoring, is the only thing that is a drawback the financial burden on low-income families? Is there anything else that you see as a drawback, or is that the main thing that we should be taking out of the testimony you offered today?
Thanks. Thank you for the questions. I don't have anything to add to what Pam Cross has said and what I've already said regarding content. It's not, I had already mentioned it.
Our time is actually right at that spot anyway, so I'm so sorry about that. Hold on to that thought, though. You never know. I'm going to now pass it over to Adrienne. You have 2.5 minutes.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. So quickly, Ms. Cross, when we're talking about the administration of justice, an e-bracelet will be administered by Quebec and the provinces, and this device is already being implemented in Quebec. But more concretely, you talked about the link between the collaboration that will be necessary between Quebec, the provinces, and the federal government, and what will be the most important aspect of this collaboration when we're talking about judicial training and ankle bracelets.
I think with respect to ankle bracelets, the most important thing here is that Quebec already has this underway as a new practice. Let's all see how it plays out there. Let's build on the research that we've already heard about today that's being done at the University of Montreal and see, is this something that's workable in a province that has a significant rural community and population, that has a very diverse population? Does it affect people from different diversities differently? I would guess yes, it does, but let's hold off making this something that's going to apply across the country till we can see how it works in Quebec and learn from that experience.
Donc, finalement,
So, last question, because I only have 1 minute left. Ms. Cross, you talked about the difference between the implementation in a rural and urban area. We talked about the accessibility and areas for the device to work. If you have any last comments on the disparity between urban and rural areas.
Rural areas are huge. Police stations are often far apart from where a victim is. There needs to be time. An electronic bracelet isn't going to provide that kind of protection.
donc, encore une fois, on en revient
So, again, we're talking about the continuum of services, so there needs to be a better training of all actors so that everyone can work on following up on the use of these bracelets.
Absolutely.
Excellent. Thank you so much. We're now going to pass it over for the next 2.5 minutes to Leah Gazan. Leah, you have the floor.
Thank you so much, Chair. My question is for Madame Cross. We know it's been widely researched that, certainly sexism, racism are a common phenomenon in the justice system. There was just a report that came out about the toxicity in the RCMP and how it's targeted towards Black, Indigenous, and people of color. Another report just came out, I think it was yesterday. That kind of bias, do you feel that the failure of judges to get proper training, do you feel that it has resulted in costing lives?
I do. I believe that in terms of both judges in criminal court and judges in family court. We've heard a little bit about Kira Kagan's story today. I think that the death of Kira is an example of what happens when a judge doesn't understand well enough the realities of violence against an intimate partner, who thinks, oh yeah, sure, there was domestic violence, but that's got nothing to do with what I'm here to decide about today in terms of who the child is going to spend her time with. I think that women die because judges don't know enough about intimate partner violence, sexualized violence, and the discrimination and misogyny that those women are facing in many, many aspects of their lives.
Thank you so much for that. I have just a follow-up question. Would you say that all judges should be provided with the training in this bill, but in order to be effective, it would have to come from using a cross-cultural lens to
Absolutely.
ensure that judges are culturally proficient in their analysis?
Absolutely. And it needs to be developed by experts outside the judiciary.
When you say experts outside of the judiciary, one of the things I find peculiar is that, they're not experts in the field, but they're deciding what they have to learn. Why is that problematic?
Because often we don't know what we don't know. And if you get to the position of being a judge, it's even true for lawyers. I'm a lawyer. I'll say it about our profession. We tend to think we already know everything we need to know. So if I don't know about something, someone else needs to tell me that I don't know that and help me know what it is I need to learn.
Thank you very much. And thank you for that last comment, Pamela Cross. I always say I'm mom, so of course I know everything, but thank you very much. Now we're just going to pass it over. Mike Morris would like to ask a question. And so I'm going to just pass it over to Mike Morris. You've got about 1 minute. 1 minute, 15 seconds. Go.
Thank you, Chair, et merci à tous les membres de la...
Thank you to all committee members. Thank you for welcoming me.
On the question that was being asked by MP Lambropoulos to C. Strauss, if C, you'd be open to sharing more about your concerns with respect to low-income folks and electronic monitoring devices, and specifically if you're recommending to simply strike out that part of the bill, or if there's another amendment that you would recommend to improve it. Thank you.
Thanks so much. We're recommending serious caution about implementing that part of the bill and potentially just striking it out. It's our view that the criminal code actually already provides judges with the tools they need in this area. The problem is not that they don't have the tools, it's they don't have the training to recognize the presence and significant dangers of IPV. So if a judge recognizes it in the criminal context, the judge has the ability to impose a condition of electronic monitoring. It's the understanding that is lacking rather than the tools that are already there.
Awesome. Well, on behalf of the Status of Women Committee, we are coming right to that point at 5:30 when I was told that we had to end today. I would like to thank all of you for being our important witnesses for Bill C-233 so that we could have this discussion. Any issues? I'm ready to adjourn. Today's meeting is adjourned. Thank you very much.